Next week, my lord, any day.
Okay,
For order.
all right.
Order.
Next week? Huh?
9.
Made please, Lordship. Lordship, I beg to mention item number 28, Lordship, of the daily list. Lordship, service report awaited, Lordship.
Okay,
Lordship, the interim order may be extended, Lordship.
okay.
Item 28.
28.
28 to 8, Lordship.
Learned Counsel Ms. R. Burwa is present. Sending Counsel.
Lordship, for
Learned
the
Counsel
petitioner,
Ms.
Lordship.
R. Burwa is present. Full stops. Service report on respondent is awaited.
Lordship.
All respondents.
Lordship, one respondent, sole respondent.
Sub respondent is awaited. List this matter after 4 weeks.
Lordship. Lordship, interim order may be extended.
Interim order shall remain in force till the next date of listing.
My lord, this matter came up for hearing on 17/7/2025, my lord, but it was deferred and thereafter it was never listed, my lord. The matter may be listed on Thursday because the appellant is an old lady and at present she is seriously ill, my lord.
Thursday. Fine. I do very first week of February, third week of February. I'm open at 15 February start open. Saturday, a first week of দুটামান ডেট দি দিব পাৰি Saturday. কিবা ডেট কৰে ডে কৰে সেইটো হিয়াৰিং ডে কৰে নেকি ডে কৰে নটিফিকেশনটো চাইছিলা নেকি 7 তাৰিখৰ পৰা 7 February নে
This Saturday is 7 February.
from 7 February
Yes.
always.
My President, I beg to mention for listing of the case MSC Appeal 2018 matters, my lord. Last occasion due to positive of them not listed. So
When
next week.
this is for hearing,
Yes, my lord. This is the order.
hearing or instruction data. We have fixed many cases for
My
hearing. So
17.
May I please interrupt? My lord, we have filed an RSA, my lord, it was registered in the month of December 2025. It has not been listed, maybe because execution will be started against us, so maybe listed on Friday.
Friday for hearing,
Yes, admission.
admission. Friday পাই নেকি? Order one. Huh? পাৰি, okay, on Friday.
Yes, yes.
Made to your lordship.
Yes.
Made to your lordship. Lordship, with the consent of the counsel for the petitioner lordship, I beg to mention item number 21 lordship. Here I am appearing for respondent number 12 to 16.
Okay.
So I am filing my wakalat number today lordship. So lordship may I will fix after 3 weeks.
12 to 16.
12 to 16.
Learned Counsel Mr.
P.N. Sharma.
P.N. Sharma has submitted that he has submitted Wakalat number, he has filed Wakalat number today for respondent number 12 to 16 and has prayed for adjournment on the consent and has obtained the consent of the other side.
Lordship.
List the matter after
After 4 weeks.
4 weeks.
Okay. Problem.
My item number 31 of today's meeting, 3 weeks time may be allowed to file objection, my lord. Order, my lord.
And have you taken consent from the
My
other
lord, I
side?
have searched for it, I could not contact the lawyer, my lord. My lord, I am the appellant, my lord.
Learned Counsel Mr.
H. Das.
H. Das has prayed for 3 weeks time to
file objection.
file objection. Okay. To file objection against the
I, my lord.
I.
My lord, there is
List
an interim order,
accordingly.
my lord, 26/9. Interim order may continue, my lord.
List accordingly. Interim order shall remain in force till the next date of listing.
May I present Lordship? Lordship, I beg to mention the listing of a MC appeal of 2017 matter. It was last listed on 6th November. The claimant is on the bed rest. Lordship, it was on the
For
that
hearing,
next.
for hearing,
Lordship,
for hearing.
for hearing, Lordship.
Jackson list কৰিবলে. How old is the matter?
2017.
What matter? অলপ urgent listing কৰি দিয়ক.
12 take over. 12. 17. Yes.
May I
Bless.
please, Lordship, we have filed a close objection filed on 16/9/25, Lordship, not listed till date, Lordship. So, Lordship, 4/2, Lordship, for admission.
For to পাই নেকি admission? 5-2,
Two cases left.
2 cases. 2 cases. Okay.
Make these the lordship. Lordship, I'd like to mention for listing of MSc appeal lordship for orders. This week lordship, any date lordship. Thursday,
For this is
6.
Hey, please,
Okay.
for listing of a IA for delay condonation, it was last listed on 25/4/25. Other side has appeared. Can it be on 18th of February, your lordship?
pardon no? Can be.
Hey, please, your
Yes, yes.
So mentioning for listing of a fresh civil revision petition, lordship. Any date in this week, lordship?
Mention.
Lordship,
Oh,
fresh
for,
listing, lordship.
for a
Civil-
motion.
Lordship.
Oh.
6th, lordship.
Appellate lordship. Lordship, I beg to mention for listing on IA lordship. Any date lordship next week.
Data. Any date কৈছে DDO.
My period. The training for lordship listing a regular second appeal lordship of 2017. Since 2020 lordship matter has not been come up lordship.
Okay, for hearing.
Lordship first let it come up for orders lordship. Then it will fix for
Orders,
hearing.
okay. 2017.
17 matter lordship.
DDO option, orders are
9 February. And lordship one MSc appeal of 2018 lordship. Any that lordship's convenience.
for hearing.
Lord hearing.
হিয়াৰিঙৰ কাৰণে দি দিয়কচোন অলপ আগুৱাই পেলাই দি দিব 2018 মেটাৰ লিষ্টটো হেৰি কৰি নিদিব Saturday to Saturday দি দিব পাৰি
No issue for on my
Ah.
part lordship. Yeah.
I don't know whether Saturday cases
Oh,
will
yes,
be
that is
taken up
also-
for hearing or not. We
Okay.
can fix it
Sir,
for
Thursday or Tuesday will be better lordship for
Thursday
hearing.
or Tuesday.
Lordship. Any Thursday or Tuesday.
Thursday বা Tuesday দি দিও
Lordship.
May it
problem.
please your lordship. I beg to mention for
Hmm.
listing of a CRP for motion
Hmm.
on 4/2/2026.
পাৰি বেলেগ ডেট দি দিও 9
Lordship, there is an urgency in this matter.
7 দি দিও on 7
Lordship, there is an execution case pending before the learned trial court. If in the meantime they go ahead with the execution case, then
When is the next date fixed? There definitely there will be a date fixed in the execution case.
Lordship 8 in this 7th.
Seventh. 6 on 6/5 on 6.
Lordship,
On fifth.
on that day my senior will be not available.
5 তাৰিখে দি দিও বাৰু
Lordship,
বেছি হৈছে নি 5 তাৰিখে
for
on 5th or 4th 5th on 5th
Lordship, as per my my senior's instruction, I am mentioning this matter for listing it on 4/2. Lordship, he
you
will
want
be
to
out
present
of,
on 5th
no lordship, on
তিনি
4/2.
2 2 আজি 3 পাৰি নেকি নোৱাৰিম on 4th
Lordship,
okay on 4th
Obliged.
May it please your lordship. Your lordship, I beg to mention item number 12, lordship. We have taken the consent from the other side. I pay for adjournment for the lordship.
learned counsel Mr.
S.A. Bhaktiyar,
S.A. Bakhtiar
item number 12,
on behalf of
N. Alam,
learned counsel Mr. N.
Alam.
Alum, comma, with the consent of the other side has prayed for adjournment. This is the matter after 3 weeks.
Lordship, a date may be fixed, lordship, because other
This is the
side has
matter 3
consented
weeks
with,
of data ta di dioksun.
in the month of March, any date may be fixed. 20, can it be on the month of March, lordship? March, first or second week? 9 months, much obliged, lordship.
My lord, I filed one CRP, my lord, 7/11, my lord, it has not been listed. My lord.
2011.
7/11/25, my lord. It has not, and 2 FAO, my lord, on 15th December. My lord, the matters are very urgent, my lord, because it led to injunction, my lord.
At which stage?
FAO is, my lord, for injunction, my lord.
Okay.
And the CRP is, my lord, regarding arbitration, my lord.
Okay.
It will be,
It's at the stage of admission.
no, new cases, my lord.
New cases.
Motion. My
Date di dioksun.
lord, my lord, if possible on 4th, my lord.
No, not on 4th.
My lord,
I'm
because
sorry, not on 4th.
then, my lord, 5th, on 6th, my lord, I'll be out of session.
You'll be out of say on 7th day.
My lord, no, I'll be for long.
Then on Monday.
My lord, let it be on 5th, my lord.
No, not on 5th. On Monday,
No, my lord, Monday,
9th,
no, then 6th, my lord.
6th.
Obliged.
May it please your lordship, I beg to mention listing of 2 RSA matter, your lordship. It is of 2013 and 15. Matter, your lordship, may kindly
2013 and 14.
15, your lordship. My lord, may kindly fix it on 10th or 11th of February, your lordship.
For what?
For your
Hearing at which
lordship,
stage?
hearing, your lordship.
Hearing.
Yes, lordship.
10th, 11th, পাৰি নেকি চাওকচোন hearing
Hearing. Similar prayer for testamentary appeal, your lordship. Testamentary appeal.
At the stage of hearing,
Yes, Lordship.
old matter,
2023 matter, Your Lordship.
it will pass on detail. Piece of. 25th.
Much obliged, Your Lordship.
Very pleased, Lordship. I beg to mention item number 17 and 23, Lordship. Matter will pass over for the day, Lordship.
Your name?
B. Devi, Lordship.
A request has been made by the learned counsel, Mr. B. Devi, to pass over the matter for the day. Item number 17 is
7 and 23.
Okay.
Matter will be taken after 3 weeks, Lordship.
list the matter after 3 weeks.
Wait, please, my lord. I beg to mention for listing CRPIO within this week or if it is possible, because there is urgency. We are the respondent in this case and we have our title suit that is stayed in the lower court. So it is not listed for long time.
This week we have only Saturday. On 7th,
Saturday. Admit for admission.
for admission,
Yes.
on 7th, yes.
May I please your lordship, I am going to mention one CRPA, lordship for hearing, listing for hearing. Lordship, any date on February, it is 2018 matter.
2018 matter.
13.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 14 of the daily list, lordship. Matter may be fixed after 2 weeks, lordship.
Your lordship, I am for the respondent number 1, 5, 7 and 8.
Learned counsel, Miss
S. Nath on behalf of Mr. S. Biswas, lordship.
S. Not on behalf of Mr. S. Biswas is present and has prayed for adjournment. Learned counsel, Miss
D. Chakravarti.
D. Chakraborty is present for respondent number 1,
1, 5, 7 and 8.
1, 5, 7 and 8. Is the matter after
2 weeks, lordship.
2 weeks.
Obliged.
May it please your lordship, I beg to mention listing of 2 MFA. One is at the hearing stage and other is on the admission stage.
At a hearing or at a, how old is the case?
Both the cases are of 2019.
Oh.
Can it be listed on the 2nd week of March? Obliged.
May I please to lordship. Lordship, I beg to mention for IA list. I beg to mention IA for listing.
Okay, when do you want?
Tomorrow,
Tomorrow? Why? What is the urgency?
because my senior is
On Saturday. 7th.
May I please your lordship? Your lordship, this is an release application, your lordship.
Mhm.
In MSc appeal, release application.
Okay.
Can it be listed on Wednesday, your lordship? Oblige.
Yes.
I need some little accommodation with regard to item number 3, my lord.
3.
But this file is not with me now, so I may be, some time, my lord, some accommodation.
your lordship.
Is there any element of settlement?
My lord, I think, I'm not aware because the
Okay.
file is not with me and it's, C is for the respondent, C.
Okay.
My lord, in that case, my lord, I'll renew my prayer when the matter is called.
You're
my
for the insurance company.
No, my lord, I'm not in this case, my lord. The file is not
Okay.
with me.
Oh, file is not with you.
When the matter will be called, my lord, I'll renew my prayer for adjournment. She has something to say, my lord.
Yes, lordship. Your lordship, the sole respondent in this case have expired. So we have the documents, but we don't know to whom we have to give, your lordship.
Let the matter be called, my lord.
Okay.
Yes, lord.
Can this be taken after some time, man? Yes, it will be only go for CD call, man. CD only.
By the way, earlier rejected, lordship, by this honorable.
Or lordship may call for the case there.
Case
Right.
Yes, lordship.
Call for the case diary, list the matter on. When do you want?
Lordship, can it be on 19th?
19th, yes.
Please, lordship. File seeking transfer of made the case number 104 of 2025, lordship, pending in the Court of Additional District Judge Nagamal, lordship, with the Court of District Judge not Lakhimpur, lordship. Lordship, here the petitioner is a government employee, lordship, posted at Lakhimpur, lordship, and she has also minor child reading in class 3 in the Lakhimpur Lordship. She'll face inconvenience Lordship when traveling to the Nagaon Lordship. And my lord, earlier also the respondent has filed a divorce petition before the court of Darang Lordship, Mangaldi. That was withdrawn on the ground that he has filed that petition due to misunderstanding. Petition is that government employee Lordship posted at not looking.
Who has filed a divorce petition?
Divorce petition is filed by the husband. Lordship.
Husband.
Husband is an ex-army officer. Lordship.
This case is pending at which stage?
Notice.
Huh?
Notice.
Sorry?
Notice.
Notice has been issued.
Yes. Notice has been issued.
Case has not, that notice has not been served as yet.
Notice has been served.
Served.
And the next date is on 11 Lordship.
For
WS.
For WS. You want a stay?
Lordship. I have a prayer, interim prayer also to be stayed.
Husband has filed for divorce.
Husband has filed the divorce petition.
Where is the petition, divorce petition?
Divorce petition, Lordship, at page 14, Lordship.
14.
Page 14.
How old is the child?
Child is reading class 3 Lordship. 9 years old. I have NFB school identity Lordship at page 29. School identity of the child, page 29. Lordship.
Where is the prayer?
Prayer portion is at page 9 Lordship of my petition.
Okay. Third learned counsel, Mr.
M. Rana.
M. Rana, for the petitioner X, who has prayed for transfer of the MATD case number 104/2025. It is submitted that the petitioner has received notice and this case is fixed for written statement. It is further submitted that the petitioner is posted at North Lakhimpur, whereas her husband is a retired army officer staying in Nagaon.
Nagaon.
It is further submitted that the petitioner's 9 years old daughter
9 years old.
is a student of class
3 Lordship.
3.
Sorry, class 4 Lordship.
Class 4. MATD 104/2025. It is submitted that the petitioner will be highly prejudiced if she has to appear at Nagaon, as she is posted at North Lakhimpur as what?
As a school teacher.
As a school teacher. To stop. I have considered the submission. It appears that that further proceeding of MATD number 104/2025 may be stayed till the next date of listing. Issue notice to the respondent returnable within 4 weeks. And further full stop D. Meanwhile, further proceedings of MATDE number 104/2025 is stayed till the next date of listing. Okay. List accordingly. Oh my God, this is an old case, 204.
She has something to say, my lord.
Yes.
Someone has expired. I
Yes,
think.
Your Lordship, the respondent number 1, Ms. Asma Begum, has expired on 8/10/2022, Your Lordship. So we have the necessary documents to give to the appellant site for substitution, but we don't know to whom to give now.
Then to come for orders, you'll have to substitute.
Yes, my lord, let it come for orders.
Okay.
Can it be after 2 weeks at least, my lord? I need to inform the company.
Yes, 2 weeks,
My
yes.
Lord, may kindly keep a record of this in the file, Your Lordship,
What?
of this documents, Your Lordship.
Required documents.
Yes, Lord.
This can be kept in the record. But you'll have to give the details
When
claimant
they are sure.
to the appellant, I mean.
Yes.
Learned Counsel Mr. R.K. Bhatra is present for the insurance company and Learned Counsel Miss
K. Sharma, Your Lordship.
K. Sharma is present on behalf of Learned Counsel Mr. G.N. Sahewal.
G. N. Sahewal, Your Lordship.
For the respondent
We are for.
claimants, for the respondent claimants.
Yes, yes.
It is submitted that one of the respondents, Mrs. One of the respondents,
Number 1, Your Lordship.
it is submitted that the respondent number 1, what is her name?
Miss Asma Begum, Your Lordship.
Asma Begum has passed away. And details of the legal heirs of Asma Begum will be furnished by to the appellants. What have you submitted here today in the court?
Your Lordship, the documents regarding the
The
death.
necessary documents have also been submitted by the respondent, which is kept in the record.
Yes, Lordship.
List this matter after 2 weeks, no? After 2 weeks. It is also submitted by the Learned Counsel for the insurance company that he is not aware about the
file is not with me, my lord. I
about the
inform
case
the
as
company.
as the file of the case is not with him.
Obliged.
Much obliged.
2 weeks list accordingly लिख दिया. List after 2 weeks लिख दिया जाएगा. We'll send for mediation.
No, Lordship, this is not a fit case for the mediation. Lordship, in this case, paper publication was made and accordingly affidavit was filed. That does not come with the case record. Sir.
Okay. Learned Counsel Mr. K.K. Bhatto is present for the appellant and Learned Counsel Mr. A. Asajja
Lordship,
is present for respondent number
number 1 to 4 claimant.
1 to
4
4.
claimant.
Paper publication for respondent number 5 and 6.
I mean, already made, Lordship, accordingly filed affidavit, Lordship, that does not come with the.
Okay. Paper notices have been issued to the respondent number 5 and 6 through paper publication. And affidavit has been filed in the support, but the affidavit is not on record. It is also submitted that there is no element of settlement in this case. List this matter in the orders column
Or order after 1 week.
after 1 week.
Yes. Obliged.
Lordship, I am appearing for respondent number 2.
May I please your lordship?
Settlement?
Your lordship, in this case, I have already returned the brief and it has been informed that they will engage some other advocate. With no objection, I have returned the brief. So at this moment, how can I say that it is? But my name is still reflected.
But you'll have to inform, no? You are returning the brief, you'll have to bring it on record.
Your lordship, then it may be come up for orders in the month of March, first week.
Learned Counsel Mr. D. Mondal is present and has submitted that he has returned the brief to the claimants, which will be placed on record. You can give a notice or something.
Yes.
Learned Counsel Ms. P. Bhattakur is present, whose there appears to be no element of settlement in this case. List this matter after 1 week.
Obliged.
May it please your Lordship. Lordship, this matter cannot be settled. Otherwise, the service is complete, Lordship. Respondent number 3 has refused notice and respondent number 4 services.
No, we will bring it on order
Orders.
column and then we'll pass order. Learned Counsel Miss
M. Sekia, Lordship.
and M. Sekia is present for the insurance company and Learned Counsel. Mr. M.
M. Talukdar for
Talukdar
respondent number
is
1 and
present
2.
for respondent number 1 and 2. It is submitted by the learned counsel for the insurance company that there is no element of settlement as the insurance company is not willing to settle the dispute. As as this appeal as they are willing to pursue the appeal. Full stop. List this matter in the orders column after 1 week.
Obliged.
Settlement or no settlement? You don't want to settle. Okay.
Lordship, regarding service, Lordship, respond number 1 to 5.
Bring it on orders column.
My lord, one just request, a copy of appeal may be given to me. I have not received the copy of appeal yet, my lord. That may be given.
Learned counsel, Mr. SP Sama is present for the for the insurance company, and learned counsel, Mr. AB Day is present for respondent number
1 to 5.
and has submitted and has requested for copy of the appeal memo, which may be furnished to the respondents by the appellants. Full stop. The learned counsel for the appellant has submitted that the insurance company is willing to pursue the matter, and as there is no element of settlement between both the parties. List this matter in the orders column after 1 week.
Lordship, reminder for the chairman to check.
Okay, issue reminder to forward the trial court record.
But you have not taken steps, I think.
Taken steps.
Issue reminder to forward the records of
No,
original
no.
records of the tribunal. Trial court records.
Hello. Deeply obliged, my lord.
Admission ready?
Yes, it can be disposed of, my lord, ex parte judgment. On the same ground, 1,500 delay there was. The same ground I have taken in the appeal, that was allowed. So matter may be remanded back along, my lord, sir. I think already the ground I have taken, that
What
was,
is the ground?
my lord, served in notice not served. That I have annexed, your lordship will find, page 23. This is postal.
Page 23.
Yes, my lord. Postal tracking, my lord.
Postal tracking.
Yes. Your lordship will find from the bottom, my lord, second column. From the bottom, second line. Insufficient address.
What is the name?
From the bottom, second line.
Second line, yes.
Item redirected to
Okay.
Shitlapur, so insufficient address. So address was insufficient. It was returned to the addressee. And on the top, your lordship will find item delivery confirmed. Second line on 12. On 3/2, it was returned. And it was delivered on 12/2 to the court itself, my lord. Item delivered to ADGS judge addressee.
To the address.
To the addressee. But
Return
the
back.
learned trial court has, it was because of oversight here. And therefore, I have taken the same plea in condoning, in delay condition petition, that same ground was accepted. Here, paragraph, ground number D, page 8.
Page 8.
D. This is the same ground, on the ground already earlier. For, I am ready to contest the case there. Ground D. बिहार ऊपर लागू पहले तुम्हारे को वो बोलो तो पता सी तो रखे In page 27, learned judge says, though notice, he, after receipt of notice, he has not appeared. And therefore, the matter was taken ex parte, proceeded ex parte. But in fact, notice not served. Page 27, paragraph 2. Okay.
Learned Counsel, Mr.
AI,
AI. Mr.
Uddin,
Your name is not in the cause list.
R Mumtaz name. I am here. I have signed the developer.
You have said it.
Yes. In the
Yes.
I also have appeared.
Okay, Mr. A.I. Uddin is present for the appellant X. And Learned Counsel, Mr. B. Dutta is present for the respondent Y. Full stop. The appellant is agreed by the ex parte judgment and order dated 12/11/2020 in connection with TSD number 75/2019 passed by the learned Additional District Judge
FPC.
Hojai, declaring the suit ex parte to the prejudice of the petitioner. Full stop. It is submitted that the petitioner is aggrieved as he has not received notice. Full stop. The annexure 3 of the petition is the, what is it called? Track consignment.
Track consignment. Postal track consignment.
Postal track consignment, which clearly reflects that the item was directed to Sitlapur. What is SO insufficient? Address?
Address was not sufficient.
SO, what is the meaning of SO?
So Sitlapur SO, that is Shodor office. That is Shodor office.
Okay. And item could not be delivered due to insufficiency of the address. So where is it that it was sent back to ADJ?
12/2/20.
Where, same page?
It was sent on 3/2/20. And the court received it, address is received on 12/2/2020.
Where is it? That the court received?
Page 23 itself, top,
Page 23, top.
first line,
First line?
12/2/2020.
Sankardev Nagar.
Yes,
First line, no?
yes, delivered, confirmed. Second line says delivered to ADS judge addressee.
Okay. The annexure 3 also clearly reveals that the notice was returned back to the addressee. Full stop. It is submitted that the learned trial court has misconstrued that the notice was properly served upon the petitioner, and the learned trial court has erroneously passed the order. Full stop. It is submitted that the petitioner will be highly prejudiced if the petitioner is not allowed to submit his or her his
Husband.
her written statement and contest the proceeding.
His, I am husband, appellant. It is an appeal.
Okay. Then it will be his, no?
His,
Petitioner no appellant. Appellant will be petitioner.
sub appellant.
Appellant will be highly prejudiced if the appellant is not allowed to submit his written statement and contest the proceeding. For the ends of justice, I've also scrutinized the annexure 3, and it's along with the petition. Full stop. It appears that the petitioner may be accorded an opportunity to appear before the trial court and contest the proceeding. I've considered the submissions at the both side. Considering all aspects and for the interest of justice, the petitioner is allowed to appear before the trial court within petitioner. Appellant is allowed to appear before the trial court within 1 month from the date of this order and some written statement to contest the proceeding of TSD number 24. 74 of 2000.
75.
75 of
19.
19. In terms of the above observation, this appeal stands disposed of. Okay.
Obliged.
May I please, Your Lordship? Civil revision petition against the order dated.
Other side is not present.
Yes, Lordship.
Will issue notice?
Yes. However, my lord, I have a interim protection, I have a prayer of interim protection that the state title should be, the lordship state till the disposal of this.
On what ground?
The lordship, this petition is filed, the defendant number, okay, respondent number 1 and 2 is the plaintiff in connection with the state title suit. However, as he has claimed that we have misrepresentation as well as forged his signature. Thereafter, one cell deed has been registered before the circle office of Nagaon. Thereafter, in the year 2019, that agreement has been registered. However, in the year 2023, they filed this title suit before the Civil Judge Junior Division Nagaon, claiming that his signature was forged, and we have malified intention. There is a malified intention, and thereafter we have registered the said deed. Accordingly, in that after the said deed, the said petitioner, the plaintiff has hand over the possession of the said land also to the present petitioner, who was defendant in the said title suit. Well, the thing is that right now.
If you want to stay, where is the order? Let me see the order.
The order is that, Your Lordship, page number. Annexure 9, Your Lordship. Annexure 9. Both sides are represented by their engaged counsel. Today is the date.
You have an IA also.
No, already IA has been disposed of
What is that IA for?
for delay condemnation, actually.
Annexure 9 page.
Page, Your Lordship, 76.
It's not a long order. Please read the order.
Yes. Both sides are represented by their engaged counsel. Today is the date fixed for order. Earlier, the defendant number 2, white petition number so and so has prayed for rectification of provision in ex parte vacating petition filed on so and so, stating that the defendant number 2 at the time of filing in the ex parte vacating petition inadvertently retained the provision as under order 9 rule 13 CPC instead of order 9 and rule 7 CPC. It is further stated that the said mistake was due to typographical error, and as such he may be allowed to rectify the said typographical error in his petition and number so and so. It is further prayed by the defendant number 2 to vacate the ex parte order dated so and so, stating that he was deceived by his previous engaged counsel after being not represented, even after allowing him to file his wakalatnama along with the defendant number 1 and 3. The plaintiff, on the other hand, has submitted written objection against the petition number so and so filed by the defendant number 2, stating that the defendant number 2 has willfully concealed the fact that the suit was fixed on so and so for written statement, and that in fact the suit was fixed on so and so for hearing on petition filed by the defendant number 1 and 3 for filing written statement. It is further stated that the averment in paragraph 2 of the petition filed by the defendant number 2 is self-contradictory with the averment in paragraph 1, as the defendant number 2 on so and so filed on ex parte vacate petition against the order dated so and so. It is further stated by the plaintiff that the defendant has failed to submit any specific provision for rectification that the wakalatnama file did not show that the defendant number 2 has signed on it. The plaintiff has accordingly prayed for rejecting the so and so filed by the defendant number 2. Heard the perusal in the case record. On perusal of the case records, it is seen that
filed order dated so and so. This court proceeded ex parte against the defendant number 2 as he was absent without any steps, and against the said order dated so and so, the defendant number 2 on the next date, that is so and so, filed an ex parte vacating petition under order 9 rule 13 CPC. According to the defendant number 2 was due to typographical error, and as such he filed the petition number so and so with a prayer for rectification of provision in the ex parte vacating petition filed on so and so. It is stated by the counsel for the plaintiff that the defendant number 2 has failed to submit any specific provision for rectification of petition. As such, the petition number 1390/2024 should be dismissed. However, it is settled law that the mere quoting of wrong provision of law does not disentitle the applicant to proceed with the application and to get the relief claimed, and that the same does not debar or prevent the court from granting the relief sought for. In the instant case, the defendant being aware of the error has instantly prayed for rectification. Considering as such, in discussion made above, I deem it fit to allow petition number also seen the written objection filed the plaintiff against the written statements filed by the defendant number 1 and 3. But here we are the petitioner, defendant number 1 and 3. We have filed our written statement after receiving the said summon in the instant case, that is the title suit number 310 of 2023. After that, we have earlier there was some other engaged counsel. Thereafter, when the stipulated time period, and that is the 90 days, on the date of 90 days, thus the petitioner has changed their engaged counsel, as the earlier engaged counsel did not give importance to their case. Thereafter, on this before 90 days, they have engaged one new engaged counsel. Thereafter, the said new engaged counsel filed one petition seeking time for filing the written statement. However, due to the said new engaged counsel fault, they have filed on the next date, which is fixed on 6/4/2024. They have filed without going through the records that the said learned trial court fixed this matter for objection of the said petition, which is filed by the new engaged counsel, your lordship. They accordingly, on that day, the defendant number 1 and 3 filed their written statement, and the plaintiff has filed their objection. Accordingly, on 27/5/2024, the Honorable Learned Trial Court dismissed or rejected the written statement of the defendant number 1 and 3 on the grounds that there was no any delay condemnation petition, or there was no any specific mention of delay condemnation. However, there is just 26 days delay, your lordship. So, my lord, my respectful submission is that, your lordship, that kindly give them an opportunity, as the petitioner, who is the defendant number 1 and who has duly purchased through registered sale deed from the defendant number 1. So, my lord, my respectful submission is that, your lordship, at least give him a chance to contest the said case with any condition, your lordship. That is my humble submission before this honorable court, your lordship.
Please complete reading the entire
Yes, lordship.
order.
Number 1 and 3, wherein it is stated that although the defendant number 1 and 3 got sufficient time, they did not file the written statement within the allotted time. It is also stated that the suit was fixed on 6/4/2000 for hearing on petition filed by the defendant number 1 and 3 for filing written statement, and without hearing on the said petition filed by the defendant, and that written statement filed by the defendant number 1 and 3 is not acceptable. The plaintiff has accordingly objected to the submission of written statement filed by the defendant number 1 and 3. Heard and perused the case records. Now, Order 8, Rule 1 of the CPC states as follows: the defendant shall, within 30 days from the date of service of summons on him, present the written statement of his defense, provided that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be prescribed by the court, for reasons to be recording in writing, but which shall not be later than 90 days from the date of services of summons. Now, it is stated, now in this instant case, the summons was served to the defendant number 1 and 3 on 11/12/2023, and the written statement was filed by the defendant on 6/4/2024 after the expiry of 90 days. However, no condonation of delay petition was filed by the defendant number 1 and 3 with their written statement. Even though it was filed after expiry of 90 days, the defendant number 1 and 3 did not care to submit any explanation for delay. It cannot be lose sight of the fact that by not filing the written statement within the time prescribed, a valuable right has accrued to the plaintiff, which should not be lightly defeated by accepting the written statement of defendant number 1 and 3. More so that when there has been no explanation of delay in filing the written statement within the prescribed period considered as such, the written statement filed by the defendant number 1 and 3 is not accepted. The plaintiff is directed to submit written objection, if any, against the petition number 1009/2000 filed by the defendant number 2. Fix this to 27.
The order was correctly passed.
Yes, Lordship. Yes, Lordship.
So how can I stay? The order was correctly passed.
However, we have filed our written statement and after 90 days. My lord, my respectful submission is that if your lordship go through,
You have just submitted the written statement and you were waiting for the written statement to be accepted.
no, your lordship, yes.
There were no grounds assigned, so the order was correctly passed.
Yes, lordship. However, we have accepted the fault of the defendant number 1 and 3. My respectful submission is that, your lordship, although there is due to the fault of the said engaged counsel, the said defendant number 1 and 3 should not be suffered. As your lordship, if your lordship go through, I have annexed the written statement of the defendant number 1 and 3 also.
Go to the written statement. Where is the petition? Have you filed any petition
Yes, lordship.
along with the written statement?
Yes,
To
Lord.
accept the written statement?
Yes.
No.
Yes, lordship.
Yes, where, which page?
Annexure number 3, your lordship.
Page?
Page 35.
Please read the petition.
In the Court of Civil Justice, Junior Division number 1, Nagaon, title suit 310 of
This is
2023.
defendant number 1 to 3.
Defendant number 1 and 3, your lordship.
Yes, please read the petition.
That the instant case is fixed today for written statement, that the defendant begs to state herein that earlier they engaged one set of counsels in connection with this case. However, there is a miscommunication between the defendant number 1 and 3 and his engaged counsel, and then the defendants asked them to hand over the brief in this case, but the engaged counsels neither did any preparation nor did hand over the brief in connection with this case to the defendant number 1 and 3 after visiting various occasions in his chamber. It is to be stated herein that the defendants also went to the office of the engaged counsel and asked NOC in connection with this case. An application for the earlier engaged counsel by asking NOC is annexed herewith and marked as Annexure 1. Therefore, the defendant number 1 prayed before this honorable court today. He engaged a new set of engaged counsels in this case and prayed some time to file the written statement for the ends of justice. On this date, your lordship, after filing this petition seeking time, the learned trial court fixed the matter for written objection on this petition, your lordship. The fault of the said engaged counsel is that he is from Guwahati. He went there. However, he did not go through the orders in connection with this case. We have accepted that there is a fault of the said engaged counsel. However, this case was fixed immediately after that on 6/4/2024. I have annexed the orders also, your lordship. Annexure 5, your lordship. Annexure 5, page number 41. May I read, your lordship?
Yes.
The plaintiff is represented by engaged counsel. The pro forma defendants so and so engaged counsel and written statement is filed on behalf of them. Take the same with the case record. Seen petition number filed by the on behalf of the defendant number 1 and 3, praying for time to file written statement. Also seen the petition numbers on file defendant number 2, praying for vacating ex parte order passed. So to pro forma defendant 6 is absent without any steps and has not filed a written statement. Considered as such, the case will proceed ex parte against the pro forma defendant number 6. Fix 6/4/2024 for necessary order. Objection. On this petition, the learned trial court fixed the matter for objection. On this petition, your lordship. However, due to the fault of the state engaged counsel, it's a bona fide mistake, your lordship. Thereafter, on that 6/4/2024, the state engaged counsel without going through the record. He filed the retained statement without having any delay condemnation proceedings. It's a fact, Your Lordship. It's a fact that there is a mistake on the said part of the said engaged counsel. Thereafter, Your Lordship, he filed a retained statement on 6/4/2024, and accordingly, the learned trial court dismissed the said retained objection of the said of the defendant number 1 and 3, the present petitioner, on 27th.
Written statement.
Yes, Lord. This is the fact, Your Lordship. And
Do you have any authority?
what
Any authority?
authority?
Any judgment supporting your case?
Yes, Lordship. Yeah, I have mentioned two judgments. However, more in my petition, page number 14.
You have the judgments with you?
Your Lordship.
You have the judgments with you?
Can I submit it after some time, Your Lordship?
Okay, then after some time.
Yes, Lord. May I please, Lord. Now, this one regular first appeal, my lord. You Lord may admit this appeal and record may be called for.
Will issue notice and call for the records?
Okay. Lord may admit also because the first appeal, my lord.
First appeal.
Lord.
Statutory appeal.
Lord.
Can admit. Appeal against judgment and order?
Judgment and order, my lord. 25/9/2025, page 11.
Will issue notice. Will issue notice. Learned counsel, Mr. Ali is present for the RLD, no?
Yes.
Is present for the appellant. Post up issue notice to the respondent or respondents.
Respondents, my lord.
Call for the trial court records. List the matter after 4 weeks. 4 weeks?
Lord.
Issue notice returnable within 4 weeks. लिख दिया, हाँ? Okay.
This is an appeal against the MSCT or the judgment for enhancement.
We'll admit it. Oh, okay. For enhancement?
Enhancement. In injury case, Honorable Trial Member MSCT has not considered our plea of disability.
Why are you aggrieved?
No consideration for disability, Lordship.
Okay. Learned counsel, Ms. S.K. Poddar is present for the appellant. Issue notice to the respondents. It is submitted on behalf of the appellant that the prayer of enhancement has been made by the appellant as the appellant is aggrieved by the judgment and order dated
13/11, Lordship.
13/11/2025.
In MSC case number 58/22. Barpeta, MSCT Barpeta.
13/11/2025 in MSC case number
58/2022.
58/2022.
Passed by learned member MSCT Barpeta.
Passed by the learned member MSCT Barpeta. It is submitted that the disability criteria was not considered and
several other enhancement upon other heads also, Lordship.
And several other heads in along with have been not considered. Full stop. Admit. List this matter. Issue notice. लिखना नहीं आएगा तो? List this issue notice to the respondents returnable within 4 weeks. Call for the original records from the tribunal. List this matter after 4 weeks.
May I please, Your Lord? The regular second appeal, my lord, the appellate court has reversed the order of the, my lord, trial court, my lord. Impugn order at page 71, my lord. First of all, my lord, the appellate before your lordship are the defendant in the trial court, my lord. The respondent are the Tea State, my lord. The Monterey Tea State Company, my lord. They have filed and sued, my lord, for right title interest over a scheduled land, my lord. And we are.
We have a caveat.
No, my lord. Here is,
Yeah, we have a caveator here.
it's item 13. Yes, my lord, there is no caveator. Item 12.
Oh, item 13.
Yeah,
Okay.
this is item 13.
All right.
Plaintiff, my lord, has filed a suit for right title interest over the scheduled land, my lord. We are the laborers, my lord. We are staying in the adjacent of the tea garden. My lord, the trial court has dismissed the suit of the, my lord, plaintiff, my lord, who are the respondent herein, my lord, on the ground that they are failed to prove their schedule, my lord. Finding, my lord, it will page 63, my lord.
Page 53.
63, my lord.
Page 63.
My lord.
Page 63 findings.
My lord, for a moment, my lord, page 61, kindly peruse, paragraph 37. It is a issue on the ground of plaintiff right title interest over the scheduled land. It is, my lord, discussed, my lord.
You are
Relevant person, page
not a
37.
defender?
I am the defendant in the main suit, my lord.
You are the defendant in the main suit.
Main suit.
Please read. Para 37.
Para 37, thus, in the light of the above discussion and from the above matter,
We'll go to the discussion there.
discussion, my lord, starts, my lord,
We'll read the main issue.
issue, my lord, page 51, issue number 5.
Page 51.
51, issue number
This
5.
is the main issue.
Main issue, my lord. Here the decision has been taken against the plaintiff by the trial court, my lord.
This order has been upheld.
Upheld, my lord. This order has been, my lord, set aside by the
Set aside.
appellate court, my lord. And, my lord, interestingly, my lord,
Okay. Earlier the suit was decreed in your favor.
in my favor. The
And
suit was
then this
dismissed.
has been set aside.
Set aside. And even, my lord, appellate court, my lord, decreed page, my lord, page 91, kindly peruse, my lord. This is the appellate court order against which this second appeal has been filed.
No, first we will go to the trial court's
My lord.
order which was in your favor.
Yes, it is in my
That
favor.
is issue number 5.
Issue number 5, my lord. It was decided, my
One
lord.
is that issue number 1 that will not read. Issue number 2 that also will not read. Issue number 3 also will not read.
My lord.
Then let's go to issue number 5. Please start reading issue number 5.
Page 51, my lord. Paragraph 23 it starts, my lord.
Paragraph?
Paragraph 23. Page
Okay.
51.
Okay.
May I read, my? The plaintiff side is claiming that Schedule 1 land described in the plaint is owned by the plaintiff number 1. Plaintiff number 1 is the, my lord, here Monterey
Tea Company.
Tea Company.
You're for a tea company.
I am for the respondent, my lord. I am the private respondent.
Okay.
And the defendant. And the name of the plaintiff number 1 has been already mutated with respect to the said land pertaining to survey DAG number 2, earlier patta number 5960/1. In support of the plaintiff case, one Kamlesh Singh, who is the resident director of the plaintiff number 1, deposed as PW1. The PW1 in his examination in chief recapitulated the aberrations made in the plaint, and the said witness submitted the compared in original copy of the document relating to his status as director of the plaintiff company as Exhibit 1. As per the PW1, the landed property described in the schedule number 1 of the plaint pertaining to survey DAG number 1, earlier patta number so-and-so, is owned by plaintiff number 1 of the suit. The name of the plaintiff number 1 is already mutated by the order of the Deputy Commissioner Karimganj in place of Pathini Tea Company Limited, along with other landed properties, and the management of the plaintiff number 1 has been maintaining sole possession and control over the landed property described in the schedule of the plaint. The PW1 exhibited the compared in original photostat copy of Jamabandi and revenue Salan as Exhibit number 2 and Exhibit number 3 respectively. However, on perusal of the Exhibit number 2, it appears that the said Jamabandi is pertaining to Moza Kuthisora, patta number 3, whereas the land mentioned in the schedule of the plaint is shown to be appearing to Moza Akai Bam, and no explanation in that regard has been given by the plaintiff side. However, the plaintiff side at the stage of plaintiff's evidence summoned official witnesses from the office of the Deputy Commissioner Karimganj, as well as Circle Officer Pather Kandi. Accordingly, one Prasant Prasenjit Sen Gupta, Amin, Office of the Deputy Commissioner, Karimganj deposed as PW2, who brought the Jamabandi relating to Pata number 5960/1, which was marked as Exhibit 9, and the copy of the said Jamabandi was exhibited as Exhibit 9(1). Another witness, Ramendra Mohan Das, Amin Circle Officer, Pathaikandi, appeared and brought the Sita and Jamabandi of Moza so-and-so, Dag number so-and-so. The said witness deposed as PW3 and marked Sita Jamabandi exhibit number as exhibit number 11, exhibit number 12 respectively. On perusal of the aforesaid exhibited document, it appears that Dag number 2 and Pata number 1 of the Moza stands in the name of the Mantri Tea Company Private Limited, plaintiff number 1. The defendant side adduced the evidence of 2 witnesses, including defendant number 1, Ratanlal Kanu. It is from our side, my lord, who deposed as DW1, and DW1 stated that their grandmother, Tarupia Kanu, was working as a permanent tea laborer of the Sefinjuri Tea Company Limited. And while she was working in the said tea state, her husband died, leaving behind his widow, minor son, Janasant Kanu, and 4 unmarried daughters. At that time, Brijmohan Kanu, brother of the said Jaisri Kanu, was living at village Kukital, and hence said Brijmohan Kanu considered the helpless condition of his widowed sister-in-law brought her family at his residence forever. At that time, the said Sarupia Kanu requested the manager of the Sefinjuri Tea Company Limited to allot a plot of land by side of the Kukital Tribe Junction in her favor to set up shop and residence. Accordingly, the general manager of the said tea company, by his letter dated 29/01/1962, allowed her to run a shop under the license agreement. My lord, we are allowed to run these, my lord, in the. And since said period, said Sarupia Kanu, along with the family of the said Brijmohan Kanu, started to run a shop over the land of said Sefinjuri Medley Tea Estate and to live over the adjoining land of the said tea estate, as described in Schedule A of the written statement. Gradually, the said shop house, constructed as a double-story building, and the defendants of said Brijmohan Kanu and Jaisri Kanu were still in occupation over more than 60 years as a permanent resident of the said locality without interruption or objection from any corner. The DW1 also deposed that the Nansan Kanu, so Jaisri Kanu, the son of Jaisri Kanu, is in occupation of the western part of the land covered by Dag number 21, while the legal heirs of the Brijmohan Kanu are in occupation of the eastern part of the Dag number 21, 22, and 23. These are the plaintiff lands. We are staying this western part of the land covered by Dag number 21. This is a suit property. Western part we are staying in the
under the Medni tea estate.
Under the tea estate.
But your land was given by Sephili tea estate. How can they give other companies tea estate? Sefinjuri Bill tea estate.
Sefinjuri and the plaintiff company, they are adjacent, my lord. They are nearby tea estate. Huh? We are residing in the boundaries, nearby boundaries, not inside within the jurisdiction.
But they cannot give permission for another tea company.
It is the tea company. Land belongs to the Sefinjuri. That's why we got the permission from the concerned tea estate.
But now you have said that that land belongs to Medni tea estate.
No, my lord.
21,
no,
23.
Western part of the land covered by the western part, my lord.
Okay.
Western part.
Okay.
Western part of the Dag number 21, while the legal heirs of the said Brijmohan are occupation in the eastern part of the Dag number 21, 22, 23 of the Moza Middle Grant. The DW1 submitted a certified copy of the trace map of the relevant Dags covered by Moza Medley Grant Part 1, as well as certified copy of the trace map of the relevant Dags of plain covered by Moza Akaidam Gaon, which were marked as Exhibit A and B respectively. Malot, kindly see here the paragraph. The DW1 submitted a certified copy of the trace map of the relevant Dags covered by Moza Medley Grant Part 1, as well as a certified copy of the trace map of the relevant Dags of plain covered by Moza Akaidam Gaon. Malot, our Moza is the Medigrant Part 1 and the plaintiff Suitland Moza is the Akaidam Gaon.
Okay.
And the defendant side also submitted the information in respect of the land under their position, which is marked as Exhibit C relating to Dag number 20, 21, 22, and 23 of Moza Medley Grant and Porgona Pratapgarh. The plaintiff side objected to the exhibit C, and the plaintiff side as well did not take any step for providing the said exhibit as per law. My lord, here the plaintiff side although objected the exhibit C, which we have exhibited, my lord, but they did not taken any step providing the exhibit as per law, my lord. The defendant side also submitted the receipt of house taxes paid by them to the Sepinguri Gao Panchayat, my lord. It is come under the Sepinguri Gao Panchayat. We have submitted the, my lord, tax receipt. And the electric consumption bill in respect of the house standing there over the land under the occupation as paid by their father, Jawaharlal Kanu, which are marked as Exhibit D to Exhibit J. In addition to the above, the DW1 also submitted photostat copy of the alleged letter issued by the Garden Authority in the year 1962 in the name of Sarupia Kanu, and the license in the name of the father of the defendant as Annexure A and Annexure B respectively. However, as the said annexures are photostat copies and the same were not as per provision of law, the same are not admissible in law. The defendant side also examined the another witness, namely Naresh Prasad Kanu as DW2. The defendant in the instance suit has claimed that the land under their occupation and position, which is described in the Schedule A of the written statement, is pertaining to settlement survey of Dag number 21, 22, 23 and Patta number so-and-so of Moza, Medligran, Pargona, Pratapgarh, whereas the plaintiff has claimed the ownership of the plaintiff number 1 over the land, Dag number 2 of the Patta number 59601 of Moza. Okay. The Dag number and the Moza are different. Paragraph 28 of the discussion. Thus, the question arose whether the suit land pertaining to Dag number 1, Patta number 1 of Moza Akaibam or the same appertains to settlement survey Dag number 21, 22 and 23, Patta number so-and-so of Moza, Medligran, Pargona, Pratapgarh. Accordingly, my learned predecessor officer on so-and-so 15/5/2008 passed an order directing the circle officer Patharkandi to survey the suit land as per the boundaries given in the plan and to determine whether the suit land is covered by Dag number 2 of Moza Akaibam or Dag number 21, 22, 23, Patta number so-and-so of Moza, Medligran. Although the circle officer Patharkandi submitted a report after surveying the land observing that the suit land is found to be covered by Dag number 21, 23, 22 and 23, Patta number Moza so-and-so, what defendant side claimed, but as there were omission in the procedure of conducting the survey and certain vital documents like field book, map were not submitted along with the survey report. Although as per survey, it was found, but there are some disputed along with the survey report. My learned predecessor, so after examining the concerned circle officer, I mean SCW1, CW2 respectively, by order dated 7/1/2022, rejected the said survey report by the circle officer Patharkandi. Subsequently, by order dated 15/2/2020, my learned predecessor office of by order dated 15/2/2020, for purpose of setting the fact as to whether the land and the land projected in the written statement are at different location or not appointed Mr. Apurva Chakraborty advocate as commissioner and assign him to take visit the Schedule 3 land of the plain as well as Schedule A land of the written statement in presence of both sides and to note down as to whether both the lands are identifiable or not, and further as to whether both the lands are separately situated or not. The said commissioner was also directed to record the existing nature and features of both the lands separately with separate schematic diagrams, and some made such noting send the diagrams for the court. Accordingly, the appointed advocate commissioner inspected the suit property in presence of both the parties and submitted his report dated 10/12/2020, wherein the commissioner had drawn 2 numbers of rough sketch map along with the report and marked as Annexure A and Annexure B. Annexure A rough sketch map not to scale had been drawn as per so-and-so. Plaintiff side or Annexure B rough sketch map was drawn as per direction given by the defendant side. The plaintiff side submitted objection against the advocate commissioner report 10/12/2020 stating that appointed advocate commissioner had not properly shown the Schedule 3 land of the plain specifically in Annexure A rough sketch map annexed with the report, and the said commissioner, beyond the knowledge of the plaintiff, used compass without taking permission from the court and submitted Annexure B with the report, which makes the report of the advocate commissioner confusing. On the basis of the objection raised by the plaintiff side, the advocate commissioner, Mr. Apurva Chakraborty, was examined as CW3, who interiorly exhibited the report submitted by him. After inspecting the suit land concerned as Exhibit 4, the spot notice to the parties as Exhibit 3, the notice to the parties as to the date of local inspection as Exhibit 2. Although, my lord, this was advocate commissioner has been appointed by the trial court, my lord, and in presence of both the parties, this has been examined, my lord, inspected, land has been exhibited. But subsequently, plaintiff has disputed that.
Yes.
The plaintiff side mainly objected to the report of the commissioner on the ground that the commissioner has not properly shown in Schedule 3 of the
Not
plan.
required.
My lord.
Plaintiff Sahib has objected.
Then, my lord,
Paragraph 33, please read.
at this juncture, it is worthwhile to mention that the burden to prove the suit land as described by the specific boundary description given by the plaintiff side in their plain falls under the Moja Akaibam and is covered by DAG number 2 of Patta number 59601 is on the plaintiff side. Although the plaintiff side, through their evidence, tried to prima facie establish the ownership of the plaintiff number 1 over the land appertaining to DAG number 1 of the Patta number so-and-so of Moja Akaibam, the plaintiff side was unable to prove that the boundary description of the land is given in schedule of the plain physically exists within the aforesaid DAG number 2 of Patta number so-and-so of Moja Akaibam. Apart from that evidence of PW1, the plaintiff side did not deduce any evidence of any person who could in fact identify the plot of the land under aforesaid DAG having boundary description as described in the schedule of the plain. But here there is no dispute regarding the property claimed by the plaintiff, my lord.
Okay, I'll come back after 5 minutes.
My lord. Just now I have read.
Paragraph 33.
Page 60, my lord.
Mm.
The PW1 as well during his cross-examination admitted that the plaintiff side had not taken any steps to ascertain as to whether the suit land falls under the either Akaidam Moja or Medley Grand Moja. Medley Grand Moja is our side, my lord, in the defendant side, holding survey through the land revenue staff of the government. The PW1 also admitted that he had knowledge that the defendants filed petition for survey of the land through revenue staffs to ascertain as to whether the suit land falls under the suit DAG number 2, Patta number 5960/1 of Moja Akaidam or covered under DAG number 20, 21, 22 and 23 of Moja Medley Grand, and that he had objection against the said petition. There is no objection filed, my lord. Further, the plaintiff side, while describing the land mentioned in the schedule number 1 and 3 of the plain, stated that towards the south of the said land, there is a land under occupation of permissive occupier Naresh Kanu under the plaintiff. This is the defendant's, my lord, relatives. However, if we consider the evidence of DW2 Naresh Prasad Kanu, he during his cross-examination stated that he got his homestead land from Medley Tea State, denied the suggestion that he is the permissive occupier under the plaintiffs. The advocate commissioner during his cross-examination as CW3 stated that PWD road is shown in the eastern boundary of the plain schedule number 3 land, while in the land described in the schedule A of the written statement, the PWD road is shown in the southern boundary. There is difference in the boundaries. And in order to mitigate the discrepancy with regard to the boundary description given by both the parties, he carried and used to pass along with him. As per the report of the advocate commissioner, after using the compass and verifying the direction coordinate points of the suit land, it has been revealed to him that the description given by the defendant side about the coordinate points of the suit land is matching with the verification of compass. Although the report of the advocate commissioner is not conclusive evidence, the judgment cannot be based solely on the basis of the report of the commissioner. The same can definitely be taken into consideration by the court along with other materials on record while
forming.
Okay,
an
okay.
open
Let
dam.
us go to the appellate court's decision on this issue.
My lord, this is
Issue
the,
number 5.
this decided negative on the,
Let's see.
against the, my
Let's
lord.
see what are the reasons
May
assigned.
this just next para, my lord, for a moment. Page, para
It's okay, I have
37.
read it.
I will read, my
It's
lord.
okay, let us go to the appellate court.
Page 91, my lord. Although, my lord, the order has been reversed, my lord, but it was partly reversed, my lord. It was
Let's see.
page 91, my lord. Page 91, para 59 is the relevant portion.
Okay.
Page 91, para 59, my lord. This is a decision, my lord.
Let's read the issue number, entire issue number 5. Para 51 of it. Para? Page
My lord,
91.
para 59 is the, my lord, decision, my lord,
No,
where
no. Let's read the reasons.
reasons, my lord, para 5 has been decided at page 83, para 37, my lord.
Yes, let's go to page 83 then.
Page 83, para 37.
Okay.
In title suit number 329 2014, the plaintiff appellants claim that plaintiff number 1 is the rightful owner of the land described in schedule 1 of the plain, which corresponds to DAG number 2 and earlier pata number 5960/1 of the Mauza Akaibam. In support of their claim, the plaintiff side adduced oral and documentary evidence PW1, the residence director of the plaintiff number 1, and submitted exhibit 1, which related to his status as director of the said tea estate. PW1 stated in his evidence that the suit land pertains to DAG number 2, earlier pata number 5960/1, that the land has already been mutated in the name of the Patini tea estate. To substantiate this, he submitted exhibit 2. So, however, upon perusal of exhibit 2, it is found that it relates to Mauza Kuthisera, pata number 3, and not to the suit land, making it irrelevant in the present context. To further their claim, plaintiff side also examined PW2 and Amin from Office of the Deputy Commissioner Karimganj, who appeared to prove exhibit number 9. Upon perusal of exhibit number 9 thus pertains to DAG number 2, pata number so and so, showing mutation in favor of Patini tea estate. Another witness as PW3 and Amin from the Patharkandi Circle Officer reduced evidence as exhibit number 11, and which pertains to which pertain to pata number 1, DAG number 2 of Mauza Akaibam. As per exhibit number 11, mutation was done in favor of Mantri tea estate, which was earlier known as Patini tea estate. Mantri tea estate is the plaintiff. Thus, exhibit 9, 11, 12 collectively support the claim that the plaintiff number 1 holds title over the DAG number 2, pata number 5960/1 of the Mauza Akaibam. On the contrary, defendant side contested the suit, claiming that they are not on the plaintiff's land. They asserted that they were permissive occupier under Sepinjuri tea estate and that the disputed land pertains to DAG number 21, 22, and 23 of Mauza Medley Grant. Two witnesses were examined by the defendant to support this claim. DW1 stated that his grandmother, Sarupriya Kanu, so and so, these are already I have read this.
You can sit down, I'll read it. Just a moment, you sit down, I'll read it. Okay, what is your substantive question of law?
My lord, substantive questions of law, my lord, at page, my lord, 6. On the ground of limitation, my lord. And the issue number 5 also, my lord, I have
This
second
limitation was decided against you.
against me, my lord.
Okay.
And basically, my lord, if the order, my lord, kindly peruse at page 90, my lord, appellate court, which is against us, my
Yeah,
lord.
I have read it.
My lord, that is also, my lord, after survey, it is declared, my lord, they are going to take the, my lord, declaration, my lord. First, they have to, my lord, circle officer is directed to survey the land, my lord. It was also not decided in favor of the, my lord, plaintiff here.
Yes, so
My-
why are you here then?
No, my lord, the execution already been filed, my lord. Therefore, my lord, before the trial court, my lord. It's
Then
title
why don't
execution
you come in the execution case?
21/2025, my lord.
Why don't you come in the execution case?
My lord,
This land was not given in possession of the. Nobody will stay this suit.
my lord,
Nobody will stay the order. I mean the appellate court's order.
my lord, the since the issue has no, my lord, the order of the appellate court, my lord, kindly peruse. It is not decided in favor of the plaintiff, my lord.
What is this IA for?
I have
Stay?
this stay, my lord.
No, you don't have any case for stay.
My lord, the advocate commissioner report is directly said, my lord,
No, but
the land
you
are
see, the
totally.
technical expert's opinion has not been accepted and the advocate commissioner's report is accepted. Nobody will stay this suit.
No, even, my lord, it is the burden on the plaintiff to decide, my lord, to prove their, my lord, schedule of the land, my lord. They have failed to prove their land, my lord, schedule, my lord. It is not within the boundary of we are holding.
There is no order to hand over possession.
Well, although there is no order, my lord, they are proceeded with the
I see
execution.
that relating to question of limitation 60 years possession, you have submitted photocopies of documents.
My lord. My lord, since in the execution proceeding already been initiated, there is no state.
No, I can admit it only on one substantial question of law, but I'm not staying.
Okay, I will take up on Friday, my lord. I'll satisfy
This
lordship
Friday?
this Friday. Or my lord, next Monday. My lord.
Next Monday, maybe.
My lord.
Okay.
I will satisfy.
Next Monday. Your name?
S. Hazarika, my lord.
Lawyer counsel Mr. S. Hazarika is present for the appellant and is paid for adjournment. List this matter on Monday. Monday ki time?
Right. I'm deeply obliged.
As far as service is complete and LCR has also come.
Lordship, kindly see the order passed in Lok Adalat. Honorable Justice SK Mehdi sitting in Lok Adalat by the order dated 14/6/25 imposed cost of rupees 50,000 on the insurance company. They have not paid the said amount till date. May I read the order?
Yes.
Pre-settlement compromise sheet has been placed on record as per which there was an agreement for payment of an additional amount of rupees 17,96,721. The settlement sheet was sent by the Learned Counsel for the claimants Sri M. Talukdar, Learned Counsel, as well as Sri Minhaj Ahmed Borbhuia, authorized officer of Reliance General Insurance Company, who is present today. Pursuant to the said pre-settlement sheet, the claimants who comprise of ladies and children have come to the Lok Adalat all the way from Barak Valley, which is more than 300 kilometers. However, Mr. Sri Borbhuia, the concerned officer, has raised an issue of further approval. An order passed by the Lok Adalat has to be on consensus of the parties. At the same time, the conduct of the insurance company is in resigning from the pre-settlement which was reached and recorded in writing is not at all encouraging, and in fact defeats the very purpose and objective of a Lok Adalat. Accordingly, the matter is deferred to be listed in the regular court. However, the matter cannot be left like this. The insurance company involved is directed to pay a cost of rupees 50,000 to the claimants for
Please pay the
causing.
cost.
I have to take instructions.
No, instruction is not required. You'll have to pay the cost.
Lordship, the authorized officer was himself present.
If you are before this court with this case, then you have to pay the cost. If you are appealing, then I don't know. Appealing against the order, then I don't know.
It is more than 6
Then you
months.
can take
Lordship.
instructions, but now you'll have to pay.
Time period may be given 1 month time period. will be given.
2 weeks time at least, at best. Because
Okay.
6 months back order, more
2
than
weeks
6.
time, okay.
That's it.
2 weeks time.
At least 1 month time is required. Lordship.
Lordship,
50,000 for an insurance company.
they have been sitting over the matter for last 6 months.
That to Reliance General Insurance Company. I'll pass an order, but not for instructions. 3 weeks time, 3 weeks
That may
time.
be recorded, Lordship.
Not for instructions, for payment. And both the parties are before this,
Right.
then we'll fix it for hearing.
Yes, it's
Lordship, the recorded, his submission may be recorded.
No.
They are going
No,
to,
I'll not
Lordship,
record his submission.
it's not.
I'm not allowing only his submission, so how can I record his submission?
My submission is recorded.
I'm not allowing only his submission. But all the parties are before this court, no?
I am
As
for
per
harassment number
126,
126,
you are
Lordship.
representing. We'll fix it for hearing then.
Yes.
Lordship.
Learned Counsel Mr. K.K. Bhatto is present for the appellant, insurance company, and Learned Counsel Mr. M. Talukdar is present for all the respondents.
1 to 6, Lordship.
Respondent number 1 to 6. Are there more respondents?
And for the other respondent, service is complete. Lordship.
Okay.
As per office note.
It is office note dated
Lordship, at first they have to pay the amount and then it will be listed for hearing.
They'll pay the amount. Office note dated 28/1/2026. Reflects that notices have been served to the remaining respondents number 7 and 8. LCR is before this court. List this matter for hearing. Meanwhile, the
Appellant,
appellant is directed to deposit the amount of rupees 50,000 as cost as per direction of this court by order dated 14/6/2025 within 3 months or within 3 weeks before the registry of this court.
Lordship, a copy of the memo will be furnished, Lordship, today itself.
Full stop. Appellants to furnish a copy of extra copies of the memo of the appeal to the respondent.
No extra copy, no copy has been furnished.
Okay. To furnish copies of the memo of.
Today itself, Lordship. Today itself. He'll forget, Lordship.
Within 3 days from today.
He'll forget.
3 days from.
Normally he forgets.
It happens because the insurance company, they have so many cases,
Yes,
Happen.
they have also so many cases, Lordship.
Mhm.
Obliged.
but not like a company. Oh. Okay. Oh, next date, no, 3 months from 3 weeks বুলি ক'লো না 3 weeks আৰু এইটো hearing টো যেতিয়া দিয়ে দিব আৰু পইচাটো 3 weeks ভিতৰত দিবলৈ কৈছে usual course নালাগে list this list for hearing within 3 weeks লিখি দিয়ে list this matter for hearing within 3 weeks.
But finally, so office note dated 19/12, my lord.
Hmm?
19/12, my lord. Office note dated, my lord.
1912.
Legally order of respondent number already substituted, my lord. I also submitted the amended cost title, my lord.
Okay, so we'll fix it for hearing.
Hearing, my lord.
Case is ready, no?
Ready, my lord. Already admitted, my lord. Substitution of law form already found, my lord.
Okay. Learned Counsel Mr. K.R. Padgiri is present for the appellant and Learned Counsel Miss
A.E. Khan on behalf of IS Law Firm.
A.E. Khan
A.E.
is present on behalf of Learned Counsel. Mr. I.S. Loskar representing respondent number 3 and 6.
2 to 7.
Or representing respondent number
2 to
Are
7.
okay, respondent 2 to 7. Okay. It is submitted that amended cost title has already been filed and substituted legal heirs of respondent number.
My lord, legal respondent number 1.
1 has been arrayed as parties to the case, parties to the appeal. Full stop. As appeal has already been admitted and as the records are before us, list this case for here, list this matter for hearing after 2 weeks.
My lord, date may be mentioned, my lord.
Mhm.
My lord, only my lord, small issue, my lord, only condone the delay, my lord.
Okay, date of the video. 10 March.
My lord.
Obliged.
Oblige.
Mhm.
Please, my lord.
Mm.
My lord, I am representing the respondent number 1 herein. The respondent number 2 had expired.
Okay.
The time of limitation has also passed. On the very last day, the last order would also reflect the petitioner has sought for time to substitute. However, since no substitution application has been filed till date and the period of 90 days is over, I pray that under Order 22, Rule 4, Sub Rule 3, the matter is already abated against the respondent number 2. So it may proceed against the respondent number 1 and other respondents.
Can proceed, but the applicant is not present today.
That I leave up to you.
Appellant is not represented today. Full stop. Learned Counsel Mr. N. Chaudhary is present for respondent number 1. Full stop. It is submitted that who has passed away?
Respondent number 2, my lord.
It is submitted that the respondent number 2 has passed away and statutory period to implement the legal heirs of respondent number 2 has already elapsed. As per order 22 rules, rule 4 of the CPC, the Learned Council has prayed that this case will proceed as this case will proceed against the other respondents as the case against the respondent number 2 stands automatically abated. Full stop. As the appellants are not present today, we can list this matter, I think, for hearing.
Yes,
For orders, no?
for orders, madam.
List this matter after 2 weeks.
Obliged, madam. Yes, madam.
Yes, 18.
My lord, I am paying for a last opportunity to hit the respondent's name.
It will last a line that but it has abated already. I think the period of limitation has expired.
Lordship.
I don't let us say submission, I do not know. Last line to the category. Learned Counsel, Mr.
MM Zaman, on behalf of Mr.
MM Roman.
Zaman, Lordship.
Zaman is present on behalf of Learned Counsel, Mr.
S. Samaria.
S. Summary. Agot likhi diba. Learned Counsel, Mr. MM Roman is present on behalf of Learned Counsel, Mr. S. Samaria, representing the appellant, and has prayed, for a last opportunity to implead the legal heirs of respondent number 2 as parties to this appeal. Full stop. Learned Counsel, Mr. M. Chaudhary is present for respondent number 1. Full stop. Okay, list this matter after 2 weeks.
Lordship, interim order is there, Lordship.
Okay, interim order shall remain in force till the next date of listing.
Highly obliged.
My lord, this industry services order was passed and accordingly affidavit is filed. There are 3 of the affidavit. It's filed on 8/12/2025.
Their affidavit, no?
Affidavit.
Affidavit has been filed.
Affidavit is served and affidavit is filed. And as per the para 3 of the affidavit, it's clearly stated that one Propon Kolita, son of Narendra Kolita, is the respondent. Narendra Kolita has received the notice on behalf of Sri Narendra Kolita and put his signature on the justice service file.
In the affidavit?
In the affidavit, in para 3, my lord, it is.
Para 3. Any return of the service report?
Yes, my lord.
No return of the service report, no?
No, my lord, it is justice service.
Okay, okay. All right.
And return of the service. my
There's
lord, it
signature
is
also.
Received
We
by
have the
Propon
signature,
Kolita.
yes.
Yes.
Learned Counsel, Mr. DCC Pukon is present for the petitioner. It is submitted by the Learned Counsel for the petitioner that notices have been served to the respondent. Only one respondent?
Only one respondent,
Respondent Narendra Kolita, and routed through justice service, full stop, and routed through justice service, full stop. The affidavit of service of notice has been filed, which clearly reflects that Tapan Kolta, son of Naren Kolta, has received the notice, full stop. List this matter for
File is completed, madam.
Oh, yes. Will list it for admission then, or
Yes, ma'am.
already admitted?
Yes, no, not admitted.
Not admitted. List this matter for admission. Records are before this court.
My lord, date
After
may
2
be
weeks,
fixed.
date,
Yeah.
you want a date? Date is the date, no?
That may be fixed, my lord,
Date
it
is
is
the
a
date.
long pending case.
List this
Okay.
matter. Records are before us. List this matter for admission on 2nd March. Okay.
Obliged.
My lord, in this second appeal, my lord, we have filed an application under section 5 of the Limitation Act for condoning the delay of 1,330 days.
How many days?
1,330 days. My lord, The petitioner, the applicant
Hmm.
has earlier filed revision petition. Wrongly, my lord, it was filed. And in the appellate court also filed a review petition. That way the matter has been delayed.
Earlier,
File revision-
appellant has filed revision petition.
Revision petition, I have stated in paragraph 3 and 4. And this is the ground of delay. And taking into account of that, my lord, previous proceeding, my lord, delay may be condoned, my lord. Whatever has been caused, my lord, that is our prayer.
Yes.
My lord, my first submission before your lordship, my learned friend take recourse to section 14 of the Limitation Act, which is wrong. My humble submission before your lordship. As per section 14 of the Limitation Act, my lord, if some petition is filed before a court without jurisdiction, that review petition, connected review petition and revision petition has been filed in a,
No, this is
in
early
courts.
revision petition. Any review petition was filed?
Well, review petition before the appellate court, first appellate court.
My lord,
And the first appellate court has no, my lord, has not entertained it.
First review petition was filed. Before first appellate court. And that was not entertained, so you
Not
have
entertained.
come against that order in.
Then, my lord, we approached this honorable court in a revision petition.
And that was
Revision
later on withdrawn.
Yes, my lord. Both these petition, review and revision, both without jurisdiction. My friend is rightly saying that, my lord, without jurisdiction, if it is without jurisdiction, the section 14 will come.
Yes, yes.
My lord.
My humble submission before your lordship, your lordship will decide only one point, whether the plea taken by my learned friend, that section 14 of the Limitation Act will apply in this case.
Okay.
My humble submission before your lordship, what petition, first the review petition was filed before a court, has got jurisdiction. And thereafter he filed revision petition before your lordship. It is not that the against review, no revision petition lie. Revision petition lie, so it was disposed of on merit. In that case, it will be wrong to interpret that section 14 will come
This
to
revision
help my,
supposed to also often merit.
yes, on
My lord.
merit.
Huh?
My lord, it was,
Review petition dismissed.
my lord, it was wrongly filed and lordship may,
Withdrawn or dismissed?
my lord, it was review petition was dismissed.
Review
Then, my lord,
revision petition was dismissed on merits.
the revision petition was filed on 12/8/2022 and the same was also closed on 7/9/2022. It was closed, my lord.
Why?
My lord, it was closed because for want of jurisdiction, when there is
Where
appeal is,
Where is the order?
my lord, I have not annexed, my lord, if lordship.
No, we'll
can't-
need the order.
My lord, will annex this, both the order, my lord.
Yes, we'll need the order.
Yes, my lord.
So we'll give you one date.
My lord,
Both the parties are represented. List this matter after 1 week
my lord,
or 2
One
weeks?
my lord, 1 week is enough, my lord.
1 week. List this matter after 1 week.
Deep lovely.
For passing order or my lord,
No.
further hearing.
Let him place his submission with the order. He has not given the order.
My lord.
And it is disputed. He is saying that it has been closed on, as it has no merits, but you are saying that
My lord,
it has been
yes, my lord.
dismissed on merits.
No, actually,
It was
review
not
petition,
decided on merit, my lord. So far.
review petition was dismissed. What does it mean? Dismissed means it is
Let's see, let him place the.
adjudicated. And second, my lord, in the review petition also, your lordship held that there is a remedy. So it is decided on merit, not that the High Court do not have jurisdiction to entertain the.
Let's see, let's see.
My lord, yes,
We'll hear you elaborate.
my lord.
Let him furnish his
Only one point, my lord.
copy.
May I please? Lordship, in this appeal, Lordship, TCR has come and all the
Yes.
respondents are represented. Lordship.
all the respondents.
So we will list it for admission there.
Already admitted for
Already
hearing.
admitted. We will list it for hearing there.
Lordship, already.
Learned counsel, Mr.
MK Hussain.
M.K. Hussain is present for the appellant. And IA has been disposed of.
No,
I
Lordship.
still pending,
Pending.
but it will come.
Okay, it's okay. And learned counsel, Miss
K. Bora, Lordship.
Miss K. Bora is present for all the respondents. As the trial court records are before us, list this matter for hearing after 4 weeks. That
Obliged.
as the trial court records now, as the records of the trial court and the appellate court. দুটা record আছে। এইটো দুটা record আনি দিছে নে trial court appellate court দুইটা লিখি দিম পাছত record নাপালে ডাঙৰ কথা হ'ব। With TCR আছে appellate court record আছে নে আছে? আছে ঠিক আছে।
Lordship, in this case, service complete, maybe come up for admission.
23 ne for it, 24. Service is complete.
Lordship.
No, my daughter, respondent number 2 died
Oh,
1.5 years
But
ago.
the report was, Lordship, kindly have a look at the office report.
So for other respondent, I am representing. my lord.
Easel Mut, it was served to all the respondents.
there's nothing report, no report relating to death, I think.
1.5 years ago died.
But you see, even that latest report, it was in the month of September. Nothing about death of respondent number 2. You obtain instructions?
Lordship.
Okay, because he will know better, no?
Lordship.
He's representing the respondents
All the respondents.
and their relatives, I believe.
Brothers.
So he will know better.
Lordship.
Learned counsel, Mr. Ella Muzumdar is present for the petitioner, and learned counsel, Mr. S.K. Gunsi is present for respondent.
For all respondents except 2.
For all the respondents except respondent number 2, whose submitted by the learned counsel for the respondents that the respondent number 2 has passed away. Full stop.
1.5 years ago.
Okay. Details and instructions relating to the relating to respondent number 2 may be obtained. List this matter after 2 weeks.
Obliged.
And steps may be taken if required for substitution may be obtained and steps may be taken for substitution if required. List this matter after 2 weeks. Likhis la, no? Please.
Your Lordship, in this matter, service report has been received on 17/10/25, and it has been received by all the respondents.
Respondent number 1 served, 2 served, 3 served, 4, 5, 6, all served.
Yes.
We have only 6 respondents.
Yes, Your Lordship.
Okay, then we will list it for admission then. Oh, this is IA, no? IA.
Yes, Your Lordship.
IA for limitation.
Yes, Your Lordship.
Okay. Okay. Then we cannot list it for admission. Learned counsel, Miss
R. Bhargav.
R. Bhargav is present on behalf of learned counsel,
S. Sahu.
Mr. S. Sahu, full stop. Office note dated 17/10/2025 indicates that notices have been served to respondent number 1, 2, 3, 4, 5, and 6. List this matter after 2 weeks.
Yes.
May I please, so as per office notes, service is complete, as per respondent number 1, 4,
2, 3 and 2, 3. 3 is answered.
Learned Counsel, Mr.
DJ Mehdi.
D.
DJ Mehdi.
DJ Mehdi is present on behalf of Learned Counsel, Mr.
And Z Bharadwaj.
G. Bhardwaj, representing the petitioners, full stop. Learned Counsel, Mr. A. Aslam is present for respondent number 1 and 2.
1 and 2.
Full stop. Office note record.
Eight 2023.
8/10/2025 indicates that notices have been served to respondent number. You are present for respondent number?
1 and 2.
1 and 2 have been served for respondent number 4 and 5. But notices could not be served, notice could not be served to respondent number 3.
Yes.
Whose unserved notices has been returned for respondent number 3 with an illegible comment on the envelope. First steps will be taken to issue a notice to respondent number 3. List after 4 weeks.
Interim order passed, interim, getting interim order, that may
Okay.
continue.
Interim order shall continue till the next date of listing. Yes.
Hello, in this case, service is complete. I am appearing for the sole respondent, Milan. So, madam, I listed for admission.
Okay.
I am appearing as legal aid counsel.
Okay. Learned Counsel, Mr.
MK Chaudhary.
MK Dr.
Chaudhary.
Item number kiman hoilo?
This is 27.
Okay. Mr. MK. MS Chaudhary or MK Chaudhary?
No, MK Chaudhary, it is reflected as Manjur K Chaudhary.
Okay, okay. MK Chaudhary is present for the petitioners and learned legal aid counsel. Mr. KM Halloy is present for the respondent. Scan copies of the trial court records are before us. Scan copies palai niki? Okay. List this matter for admission after 2 weeks.
Lordship, an interim was there, so it may be extended.
Okay, interim order shall remain in force till the next date of listing.
Much
obliged.
In this case, there is a sole respondent. But in the notes, office note, it is reflect that no person in such order, in such area. Maybe permit first step as usual as Dusty.
Office note date, learned counsel, Mr.
L Deca.
L Daga is present for the for the applicant. For some office note dated 22/10/2025 indicates that no such person resides in the given address, full stop. Now, fresh notices may be, fresh steps may be taken to issue notices to the respondent through routed through justice service as well as per usual process. List after 4 weeks.
Yes. Observe.
The Lordship. Lordship, in this case, he has appeared for the claimants, they are the main aid, but the owner was also a party. The service on him is not complete, but I have discussed with my manager, matters and delay can be condoned. And at the appellate stage, after admission, we can send notice to him again.
Again, notice of Lordship.
This is again otherwise delay because.
Delay may be condoned. I have no objection on that.
Learned Counsel Mr. P. Bottomley is present for the applicant. Huh? Oh, sorry. I'll be showing. Here, P. Bottomley was written. Sorry, very sorry, Mr. R. Bottomley is present for the applicant, stroke appellant, and Learned Counsel Mr. M. Khan is present for the claimants.
Claimant 1 to 4.
One claimants. It is submitted that the learned counsel for the claimants have no objection if delay of 173 days is condoned, full stop. It is submitted for the applicants that the delay was not intentional, full stop, as
Explain in para number 2.
delay was not intentional, but was a result of forwarding the decision of the learned tribunal hobo na, dated 6/11/2000.
Commissioner, not Commissioner for Workmen's Compensation.
Learned commissioner dated, what is the date? 6/11.
6/11.
6/11/2024 in connection with a case to number to diya thakibo, huh? Bongaigaon EC case number 9 of 2020 to the head office.
Yes, sir.
To the head office. I have considered the submissions at the bar with circumspection. No mala fide is discernible. No mala fide could be deciphered. Could be deciphered. Delay is hereby condoned. Registered to register the connected appeal.
And in appeal, my name may be reflected, Lordship.
The name of Mr. M. Khan is to be reflected as learned counsel appearing for the claimants.
Yes,
Stroke respondents. Yes.
But see, in this case, I have to take step upon the respondent number 5. There was no reflection in the order, let's see, regarding taking step upon the respondent number 5.
Oh, there's a respondent number 5 also, no?
Yes.
Okay, no reflection, no?
No reflection.
Okay, but the other respondent is not present today.
1 to 4 has already appeared.
Yes, they have appeared, but today he is not present. Learned counsel Mr. K.K. Bhatto is present for the appellant. For sub, the respondent number 1, 2, 3, and 4 are not represented today. Steps may be taken to issue notice to respondent number 5 returnable within 4 weeks. List accordingly.
Yes.
May it please your lordship.
IA
lordship.
IA
for injunction, lordship.
Injunction?
Yes, lordship. In this case, what happened, lordship, my regular second appeal was admitted on 22/10/2025. And thereafter notice was issued in stay petition as well as in regular second appeal, lordship. And the respondents are now disturbing in the peaceful cultivation by the appellants in the cultivated area, suit land, lordship. So this IA for injunction.
Respondent is present, no, today?
Lordship, I am from
Notice
inside
issued,
Lordship,
Lordship.
private
From
respondent
government,
here,
okay.
Yes,
Lordship.
await service report for the other respondents. Lordship, but I have filed this injunction petition under order 39, rule 2, 1, 2 and 3, Lordship. Even without issuing notice, your Lordship has power to grant injunction, Lordship. Since the date of purchase, 2012, we have purchased by registered sale deed from the one of the defendant, Lordship. So now the other sisters are claiming that that sister has no right to sell the land to the defendants, Lordship. We were the defendants in the suit. So they prayed for cancellation of the registered sale deed in our favor. And we have purchased by registered sale deed in the year 2012.
The land was not partitioned maybe.
Lordship, their case is that she was minor at that relevant point of time, and she has sold out the land in excess of her share. Whereas, Lordship, in the sale deed itself, father is the identifier of the seller. And Lordship, we have purchased by the registered sale deed. So, Lordship, as per Evidence Act, also there is a presumption in respect to a registered sale deed, Lordship. So, my appeal already admitted, Lordship.
You have annexed the sale deed?
No, Lordship. Sale deed will be in LCS.
Sale deed.
And that is admitted. In plain, they have admitted, Lordship. For that only, they prayed for cancellation of the
You have
sale
annexed
deed.
the plain?
Yes, Lordship. In the regular second appeal, your Lordship will find.
You are the defendant, no?
Yes. Page 8 is the plaint. In the main regular second appeal.
Okay. Pertaining to that, you have given the plot of land, described
Yes,
the plot
in
of
my
land in
injunction
this
petition,
IA.
in my injunction petition also, I have
So
mentioned
I am
page,
asking about the injunction petition only.
page 10.
Page 10 and your sale deed
Sale deed, I have
in
not.
RSA,
RSA plaint is page 8.
page 8. Page 8?
8.
Okay.
And the schedule of land, page 12. As per their plaint. That is the land we have purchased.
Why is the government added as a party?
Lordship,
Because of SDC's order,
plaintiff made them party.
or SDO.
Yes, Lordship. State of Assam represented by
2 bigha, 1 katha, 1 lesser, covered by
State
DAG
of Assam
number.
represented by Deputy Commissioner Dhubri, Sub-Registrar and ASO.
Because of the sale deed maybe.
Lordship, the partition they sought for.
Oh,
In the-
partition. Okay.
Yes, for partition DC will be required. And they prayed for cancellation of the sale deed also. Their second prayer is that to declare that the sale deed number so and so is void, ab initio and illegal.
Okay, this land is okay.
Yes, and their
But
case is-
what is your prayer?
and their case is that they sought for recovery of possession. So it means that we were in possession since the date of purchase. The plaintiff themselves admitted. My case is that, Lordship,
Now what is your issue?
my case is that they disturbed in the cultivation process. The date I have also mentioned.
Hey, here is
Page-
CPC on here, sir.
Page 6, para 2. The 39 rule 150. Page 6, para 2, the case of the plaintiff, and page 7, para 3, I have mentioned that on 13/1/2026, the
Where,
defendants.
page 6, para 2?
Para 2, this is the case of the plaintiff. And para 3, I have mentioned that the applicants who purchased the suit property by valid registered sale deed from the respondents by paying consideration amount where are cultivating the same since the date of purchase. But now after winning the suit in both the courts, the defendants are trying to disturb in the cultivation process. On 13/1/2026, the defendants came to the suit land and tried to restrain the applicants from cultivating, but at the intervention of the police people, they returned. Though they returned from the suit land, but they informed the local police station and local police asked the applicants to appear before them on 15/1/2026. Accordingly, the applicants appeared before the Gulabganj police station on 15/1/2026 and apprised the police that though they lost in both the courts, but their appeal was already admitted for hearing before the Honorable High Court. But the police are pressurizing the applicants to show any order from High Court which allowed them to cultivate in the suit land. Otherwise, they are not allowed to cultivate the suit land. So this is my case, Lordship, and this is the only plot of
What
land.
do you want to cultivate now?
Lordship, this is the season, Lordship, for the
What cultivation? What crops?
Lordship, as per their Lordship, they informed me that they are going to Rui Bunane because I am not aware about that.
You see, this is not the
Rice-
cultivating
rice
season
or
now.
something, Boro kheti or something. My learned friend knows. I am not aware about that. This told me some word in Rui Bunar time like it.
Kothia is sowed in summer and vegetables are sowed in winter.
No, Lord.
So now what
rice
to cultivate, I don't know.
Actually, in that side, Lordship, Boro Kheti is there, Lordship.
Oh.
That is called Boro Kheti. And in particular area, it is called Iri. Paddy cultivation.
cultivation, they inform me.
Paddy cultivation.
Because our side the fields are lying
No,
vacant.
our side, this is not, that is not available.
Then Dhubri district, Lordship. Lordship,
I don't have any idea about
Yes,
the
yes,
stuff of
it is already
cultivation.
admitted, Lordship. They may come for
Only for
modification.
cultivating,
Lordship.
nothing more than that.
Yes, Lordship. This is a
Let's
cultivable
see,
area.
what is your petition on the section?
39 rule 1, 2 and 3. Read with section 151 of the Code of Civil Procedure. And 39.3 says, Lordship, even without issuing any notice, your Lordship can grant injunction to the petitioner, Lordship.
And then what is your prayer? They are not allowed to cultivate suit is the only plot of land where they cultivate rice. Rice.
Yes.
Is written here, rice.
Yes, Lordship.
Yes. That's why I'm asking, what do you want to cultivate?
They told me some word, Rui Bunai ne ki kila kuch. My prayer is that Lordship, an order of temporary injunction directing the opposite parties, their men, agents, or any other person authorized by them
No. Only cultivation.
not to disturb in the peaceful possession of the applicants over the suit property and or a direction may be given
No
to
peaceful possession and all,
the
only
opposite
cultivation.
parties, their men, agents, or a person authorized will not to disturb the applicants in doing cultivation.
Only cultivation, no peaceful possession and all. Only
Lordship.
cultivation.
Yes, Lordship. Lordship may direct that the applicants are allowed to only cultivate the suit property.
Rice. Boro dhan, no?
Boro dhan.
Nowadays, in our side,
No, not
is
available.
there, you see all the fields are lying vacant.
Yes.
Absolutely dry.
I have no idea.
You try visiting our side sometimes. Upper Assam.
Exactly, Lordship.
They have not filed any Lordship execution proceeding also. We have not received any notice from executing court. So in my stay petition also notice was issued. And accordingly, I have taken step in both the cases.
But Learned Council Miss R. Chaudhary, IA to likhiba. Ha, IA number duta IA ase.
178.
This is 173, I believe. Oh, 178.
178.
We don't, oh, RSA is 173.
Yes.
IA 178. Miss, what is the number?
It's 178, Lordship. In RSA number 173 of 2025.
32, neki? 33. 34, 35, okay. It 178 day. 178 ote order to diba. Learned Council appearing for the applicants who are aggrieved by the conduct of the respondents, full stop, it is submitted that the respondents have that the respondents have a decree in their favor by TS number
Right, TS number, Lordship.
137 of 2014 and TA number 21 of 2024, full stop. The land described in the schedule of this application is the suit property which is under the possession of the respondents or of the possession of the applicants. Full stop. The judgment and the decree in both the title suit and the title appeal clearly reflects that the applicants are in possession of the suit land. Full stop. The applicants purchased the suit land through a registered sale deed, which has been disputed by the minor, by the
plaintiff's respondent.
By the plaintiffs, stating that plaintiff, what is her name, was minor at the time of the execution of the
Plaintiff,
sale deed.
Lordship, vendor of the sister of the vendor, Lordship. Three plaintiffs, Lordship. Plaintiff's allegation is that
who is the minor? Her name?
Bobita Biswas.
Plaintiff. She is the plaintiff now, no?
She is defendant, Lordship. But she has not contested the suit.
Okay, okay. By plaintiff nalage, by defendant Bobita
Biswas.
Biswas was a minor at the time of the execution of the sale deed. Full stop. As the decree was in their favor, the as the decree and the order in the first appellate order of the first appellate court was in the favor of the plaintiffs, comma, the plaintiffs have encroached into the suit land to the disadvantage of the present applicants. Full stop.
They have not encroached, Lordship. They disturbed.
Or they are
cultivation
disturbing.
process.
They are disturbing the peaceful possession
Cultivation.
of the present applicants. Full stop. It is further submitted that the applicants have already preferred a second appeal, which has been admitted in this court by the order dated 20/10/2025, and the second appeal is registered as RSA number 173 of 2025. Full stop. It is further submitted that the applicants have every scope of getting a decree in their favor. Full stop. Now the applicants being debarred from cultivating their land are suffering immensely. Full stop. At this time, the applicants cultivate a type of rice, a type of paddy stroke rice. And if they are not allowed to cultivate the crop, comma, they will suffer immensely. Full stop. Learned government advocate
T.R. Gogoi, Lordship.
T.R. Gogoi is
Lordship.
present for respondent number
678, Lordship.
6, 7, and 8. Full stop. I have considered the submissions at the bar with circumspection. Full stop. As the second appeal has already been admitted, comma, the plaintiffs stroke respondents are thereby restrained from opposing.
Lordship, respondents, namely the name may be inserted.
Respondents naam likh diye.
Namely 1, 2, 3, 4, 5.
From cultivating paddy stroke rice in the aforementioned or in the suit land mentioned in the application.
Lordship.
Until further orders.
The applicants are allowed to cultivate, Lordship. Lordship, the applicants may be allowed
I'll
to
pass an
cultivate,
appropriate
Lordship.
order.
These 5 persons may be restrained in
Only for
disturbing.
only rice.
Lordship.
Only for cultivation.
Respondent naam kita likhasan.
1 to 5, Lordship. This is Arpana Biswas, Jyotika Biswas, and Reba Biswas, Bobita Biswas, and Vishnu Ram Biswas.
Shall not disturb here, disturb the applicants from cultivating the paddy stroke rice in the suit land until further orders.
Lordship,
Issue notice to the respondents litigant.
Lordship.
List this matter after 4 weeks.
Obliged.
Obliged, Lordship.
Ah.
And
Nalage, nalage.
35 is Lordship already notice issued.
Notice.
The service report is awaited in RSN, in RSN and
Service report is awaited.
Lordship. Obliged.
Yes. Yes, yes. Now, will it be, do we have sufficient time?
Lordship, in
Two
item
minutes.
number 32, respondent number 4 expired, who is mother of the appellant as well as
32.
respondent number 1 to 3.
So his name will strike out, I'm appellant here.
And case may be fixed for hearing.
Maybe stuck off.
Strike out.
Maybe.
Learned counsel, Mr.
Anand Jha, your lordship.
32 likhas on 32, no? 35. Mr. Anand Jha is present for
Appellant.
35.
32, Lordship.
32.
Hearing
Okay,
item.
okay. Oh, Learned counsel, Mr. Anand Jha is present for appellant, and learned counsel, Mr.
R. Ali, Lordship.
R. Ali is present for respondent number
1, 2, and 3.
1, 2, and 3. It is submitted that the respondent number
4 expired.
Correspondent number 4 expired.
4 has passed away. So we'll list it for substitution of legal heirs.
No, madam, his name may be a strike
Oh,
out.
it is submitted by the learned counsel for the appellant that the name of respondent number 4, Mr. What?
Bulbuli Khatun.
Bulbuli Khatun.
Srimati.
Mrs. Bulbuli Khatun, alias.
Srimati Bulbuli Khatun may be struck off as she is already being represented by the other respondent.
Yes, sir.
Full stop. Considering the submissions at the bar, the name of respondent number 4, Srimati, it passed away now, like Srimati in Hobart, Srimati Bulbuli Khatun is to be struck off at the risk of the appellant. Huh?
Cases of
List this matter.
2018.
Okay. List this,
Partition case, maybe on
list this
12
matter for hearing.
12 February, Lordship. It's a partition matter since 8 years. It will not take so much time, Lordship. Partition matter.
It will take time, your lordship.
Partition matter.
Between brother and sister.
Herring is take time.
Lordship.
17.
19, Lordship.
19.
Last part of the
19.
last part
List
of
this matter for hearing on 19 February.
19 February.
your lordship.
We'll hear it in the afternoon. After at 2 p.m. we'll hear
Yes,
it.
lordship.
অলপ আছে যে হেন্দি গলে অথনি যে শুনি তাৰপিছত অৰ্ডাৰটো বিচাৰি যায় শুনাৰ পিছত সেইটো কাৰণে অলপ ভাবিছে ভালকে শুনিব বুলি
Yes, yes. Paragraph 46.
Paragraph?
46. Last, last page. 419 and page number. Yes, I have highlighted it. Paragraph 46, we sum up and briefly state our conclusion as under. The trial of an election petition commences from the date of the receipt of the election petition by the court and continues till the date of its decision. The filing of the pleadings is one stage in the trial of an election petition. The power of vesting in the High Court to adjourn the trial from time to time and with as far as practicable and without sacrificing the expediency and interest of justice includes power to adjourn the hearing in an election petition, affording opportunity to the defendant to file a written statement. The availability of such power in the High Court is spelled out by the provisions of the Representation of the People's Act 1920 itself and rules made on purpose of that act, and resort to the provisions of CPC is not called out. On the language of section 87 clause 1 of the act, it is clear that the applicability of the procedure provided for the trial of suits to the trial of the election petitions is not attracted with all its rigidity and technicality. The rules of the procedure contained in CPC apply to the trial of election petitions under the Act with flexibility and only as guidelines. In case of conflict between the provisions of the Representations of the People's Act 1951 and the rules framed thereunder, or the rules framed by the High Court in exercise of the power conferred by Article 225 of the Constitution on the one hand, and the rules of the procedure contained in CPC on the other hand, the former shall prevail over the later. the purpose of providing the time schedule for filing the written statement under Order 8, Rule 1 CPC is to expedite and not to scuttle the hearing. The provision spells out a disability on the defendant. It does not impose an embargo on the power of the court to extend the time. Though the language of the proviso to Rule 1, Order 8 CPC is couched is negative form, it does not specify any penal consequences following from non-compliance. The provision being in the domain of the procedural law, it has to be held directory and not mandatory. The power of the court to extend time for filing the written statement beyond the time schedule provided by Order 8, Rule 1 CPC is not completely taken away. Though Order 8, Rule 1 CPC is a part of procedural law and hence directory, keeping in view the need for expeditious trial of the civil causes which persuaded Parliament to enact the provision in the present form. It is held that ordinarily the time schedule contained in the provision is to be followed as a rule, and departure therefrom would be by way of exception. A prayer for extension of time made by the defendant shall not be granted just as a matter of routine and merely for taking more so within the period of 90 days has expired. Extension of time may be allowed by way of an exception for reasons to be assigned by the defendant and also be placed on record in writing, whosoever briefly by the court on its being satisfied. Extension of time may be allowed if it is needed to be given circumstances which are exceptional, occasioned by reasons beyond the control of the defendant, and grave injustice would be occasioned if the time was not extended. Costs may be imposed and affidavit or documents in support of the grounds pleaded by the defendant for extension of time may be demanded, depending on the facts and circumstances of a given case. In the case at hand, the High Court felt satisfied that the reason assigned by the defendant appellant in support of the prayer for extension of time was good and valid. However, the prayer was denied because the High Court felt it had no power to do so. The written statement has already been filed in the High Court. We direct the written statement shall now be taken on record, but subject to payment of rupees 5,000 by way of costs payable by the appellant. Herein to respondent 1.
Okay, all right. I'll send it back.
Yes,
You
Lordship.
file a petition
Yes, Lordship.
for acceptance of the written
Lordship,
statement.
Lordship.
Okay, and the court will consider the petition
One.
in accordance with law.
Lordship.
I'll not issue notice to respondents.
Yes,
then.
Lordship. Yes, Lordship.
Item number?
Item number 9, Your Lordship.
Heard learned counsel Mr. S.D. Roy.
Lordship.
For the petitioner, नाम कितना लिखी दिया हाँ, who have filed this application under, where is the prayer?
Prayer is at page number, Your Lordship. Well, 14 and 15, Your Lordship. In the premises aforesaid, it is most respectfully Your Lordship to admit this petition, call for the records and issue notice following on the respondents to show cause as to why the instant revision shall not be allowed as prayed for the settings at the
Okay,
instant.
file an application, who has filed this application under Article 227 of the Constitution of India, read with Section 115/151 of the Code of Civil Procedure. This is 1908, I think. You have written 1905 in the application. So, so to give on Civil Procedure Code within brackets CPC for short, full stop. It is submitted by the learned counsel for the petitioner that the petitioners may not suffer due to the conduct of the engaged counsel, full stop. It is submitted that the petitioners are defendants
Yes.
in title suit number
Title suit number
310 of 2023, and they and after expiry of 90 days, they have filed a written statement, full stop. The learned trial court rejected their application as rejected the
Written statement.
written statement as no reasons were assigned. No reasons were assigned for the delay in filing the written statement, and after the statutory expiry of the statutory period of 90 days, full stop, it is submitted that the learned trial court has held that the petitioners have failed to file any petition for condonation of delay in filing the written statement, full stop. It is submitted on behalf of the petitioners that the petitioners had engaged a new counsel to represent them as they were not satisfied by the conduct of the earlier engaged counsel, full stop. And the new engaged counsel was present before the court on
11/3/2024, Your Lordship.
page number.
Page number. Annexure 3, Your Lordship, page number 35. And order is at
Before the court on 11/3/2024 and filed a petition which is marked as Annexure B of Annexure 3 of the instant petition, full stop.
order at page number 41, Annexure.
Without going through the earlier order, the learned counsel, the newly engaged counsel submitted the written statement
statement.
without assigning grounds for delay in filing the written statement
On 6/4/2024, Lordship.
on 6/4/2024.
Annexure 8, Your Lordship.
Annexure 8
Page number 73.
is the written statement
No, Your Lordship.
or the impugn order.
Yes.
Thereafter.
No, impugn order is not Annexure 8. Impugn order at page number, Annexure 9, page number 76.
I do not want to go through the written statement.
Yes, Lordship.
Thereafter, the impugned order dated 27/5/2024 was passed. The petitioner has also relied on the decision of the Honorable Supreme Court in Kailash versus Nangpo and others reported in within bracket 2005 bracket close 4 SCC 480, wherein it has been held that paragraph 46 voted to likhi diba. 46 or 47. It has been held that reverting back to this case, it is held that the petitioner, Petitioners, Your Lordship, defendant number 1 and 3.
1 and 3.
The petitioners 1 and 3, who are defendant number 1 and 3 in the original title suit,
Yes, Lordship.
may be accorded an opportunity to submit the written statement and contest the submit the written statement. Full stop. The accorded an opportunity to submit a written statement accompanied by a petition. Full stop, comma, accompanied by a petition assigning reasons for delay in filing their written statement.
Gotcha.
Full stop. Thereby, for the interest of justice, and considering the submissions at the bar, comma, without issuing notice to the respondents, comma, the order dated 27/5/2024 is set aside, comma, allowing an opportunity to the petitioners to appear before the learned trial court and file a petition along with the written statement, which may be considered by the learned trial court afresh in accordance with the law. Full stop. The petitioners are directed to appear before the learned trial court within 1 month from the date of this order.
Next date is, Your Lordship, 9/3/2025, 26, sorry. On that particular date. we
Within
are-
1 month there.
Yes, Lordship.
On the next date fixed here. The petitioners are directed to appear before the learned trial court within on the next date fixed
Yes, Lordship.
and submit their petition along with the written statement.
Lordship.
In terms of the above application, this petition stands disposed of. Over, no? List.
Deeply obliged, Lordship. Deeply obliged.